Hello and welcome to the ET Legal World International IPR Virtual Conference. The agenda of today's event is set around the theme of decrypting the intricacies of intellectual property in the post-pandemic era. The dynamic IP realm has experienced a surge in innovations owing to the coronavirus pandemic. A rise in collaborations across the wide network of innovators and organizations has amplified the need to warrant better protection to IP rights and set up frameworks to keep up with the rapid globalization of innovation and to convert ideas into thriving business ventures. Innovation in technologies has catapulted us into an era which demands a secure way of enjoying innovative properties and mitigate the risk arising from use of such next-gen technologies. This ever-evolving journey of the intellectual property realm has induced us to engage in insightful discussions pertaining to the intricacies of the IP sector, especially in post-COVID era. ET Legal World International IPR Virtual Conference presents a platform congregating leading experts from across the globe to decipher and interpret the importance of innovations for businesses and industries to ensure fusion of actionable approaches enabling organizations to transform intellect into thriving ventures. We aim to encourage robust discussions pertaining to themes surrounding the concept of IP in cyberspace, the capitalization of IPs by startups, the ability of AI to hold patents, the future of public-private proprietorship, the fight against counterfeiting of design and products in the wake of rising e-commerce and digital media, leveraging IP as collateral to secure funding, and more through this platform. We extend a warm welcome to all our speakers and attendees and hope that this virtual conference will be beneficial for all. The virtual event will not only offer the attendees an opportunity to network with connoisseurs and decision makers possessing a holistic global perspective, but will also provide an excellent forum for ruminating and exchanging ideas with various industry experts. This event was possible because of the support by the group of partners. It's my pleasure to thank their contribution on this platform. A big thank you to supporting partner H.K. Acharya and Company and Singh and Associates, industry partner Indian National Bar Association IRRO, Indian Reprographic Rights Organization ICC, Indian International Chamber of Commerce IPO, Intellectual Property Owners Association, Event Tech Partner vConfex, and this is an initiative by etlegalworld.com. The hashtag for this summit is ETLegalWorld. So let's make it big by spreading word on social media using the same hashtag. Let's begin with the first session. Emerging technologies are leading the way for the creation of more IPs in India. The thrust for IP has intensified, and that brings the basic question to the forefront. Strategies to safeguard your IP, the business strategy to not infringe someone else's IP, or having a robust mechanism to be able to use the latest technologies and take maximum advantage from them for your businesses to thrive. In this session, we will discuss such key aspects. I would like to invite Neeraj Dubey, partner, corporate practice Singh and Associates, Shrimant Singh, partner, patents, design, IP transactions, Singh and Associates, for the discussion on emerging technologies and IP concerns. Over to you, gentlemen.
Hi everyone. In today's session, we would discuss the IP concerns on the emerging technologies in India. When I say emerging technologies, it can be IoT, virtual reality, cloud-based games, geomapping, drones, smart vehicles, quantum computing, edge computing, AI, machine learning to begin with, and a lot more. These technologies are also empowering segments like marketing, retail, healthcare, science, industry, and many more sectors, and defining and redefining the way these sectors work or function. With this background, Shrimant, my first question to you. What strategies would you suggest for the companies engaged in these emerging technologies to adopt to protect their IP in India?
Thank you, Neeraj. Thank you for the good introduction that we had about the emerging technologies. With respect to, strategies, with respect to technologies, I would say that times are changing, and so is the need for change in strategies as well. Conventionally, the IP as a strategy was more on a conservative side, where you need to focus on your own technologies and work on it and maybe monitor it to some extent. Lately, we have found with our clients, domestic as well as international, they are now moving on to actively monitoring IP not only internally, that is within their teams, R&D, marketing, and legal. They themselves kind of doing the next steps of IP, where they want to head it to. Now they are also interested in knowing external aspects as well. That is keeping a watch in the competitor market, in the technology domain, and stuff like that, which is, I think, very, very good, way to go for emerging technologies, especially because, a lot of path breaking aspects are here that need to be implemented. And the more you know about the area, the more you know about the technology, the better it is. Internal as well as external management or monitoring of IP is one thing that I would like to highlight here. And the second thing is to be meticulous about your IP management. By meticulous, I would say that you need to be very particular, not only about the subject matter of IP, not only about how well the IP should be drafted, how well it should be protected, but also about the formalities that are involved in the IP protection, which includes maintaining the timeline, which includes docketing the actions properly, which includes monitoring the timelines to an extent that there is not a single chance that you miss. So you'll be surprised, Neeraj, that there are more than 30 to 40% cases where clients, and I'm talking about big corporate clients who have huge portfolios of IP, and they are IP or maybe technology-based companies. Still, there are instances that they face losses in terms of IP protection because they are not able to keep up with the timeline. Some or other deadline is missed in a jurisdiction that they were, although monitoring, but maybe not very active on it. So as a strategy, two main pointers: internal as well as external outlook both are equally important. The emerging technology sector should focus on that. Second, please try to be meticulous and automate the timekeeping, the docketing, the formal requirement management. Most of the firms in US, Europe, and now in India, we have been using it for a long time at Singh and Associates, but most of the firms are now adopting those softwares, and emerging technologies should also. It's, so as to lessen the manual intervention and the human error that might cost you a case, cost you an IP. So yeah, these were the main pointers for improvement on the strategies that the companies have.
Yeah, interesting. So it was interesting to hear that a lawyer is suggesting emerging technologies companies to use softwares to manage or protect their IP. That's a wonderful suggestion. It would be easier for them to actually understand the nuances and adhere to it. Now, when it comes to organizing the entire gamut of IP, the company should make, I believe, maybe you can correct me, a comprehensive IP policy for their organization to cover the aspects of, say, identification, how they stumble upon or do R&D and identify IP, how to go about registration, and the process of entire IP lifecycle in their organizations, IP data management, the documentation
Right.
or management that you mentioned, including the aspect of protection and training their people. Like,
Yeah.
as a lawyer who is not into IP practice, one would not be able to identify what an actual IP would be, which would be IP, which would not be, right? And those who are indulged in R&D practice of the organization, R&D division, how would their aspects should be, I would say, streamlined so that they don't take away any IP because they know what IPs
Yeah.
are, and they should not be taking away any IP of the company. So what would be your suggestion in this regard?
Yeah, that I think to have an IP policy, every other technology-based organization, be it a small one or a large one, they know the importance by now. And to have it as defined as possible is now equivalent to having a comprehensive HR policy. You need to have a comprehensive HR policy for smooth functioning of your organization and HR. Similar is the case with IP. You have rightly pointed out, the basic stages that to be kept in mind, starting with the identification of IP. First of all, sensitizing people in your organization. And I would say it is not limited to R&D. It is very much involved when yeah, in case a marketing department is there, they should know that what IP they possess, and that is a big selling point for any organization. How aggressive are they with respect to creating IP? How aggressive are they with respect to keeping the records of IP in a clean format or a very managed manner? And how aggressive are they in protecting it, registering it, and then enforcing it? So it's not something that would lie on paper now. So as you said that being a lawyer, yes, I'm definitely advocating the fact that you should involve softwares and AIs and time management tools wherever possible, so as to remove all the human errors that were there previously, and the companies have suffered because of that. So you have these docketing systems that you can definitely introduce either to your organization, or maybe what the clients are preferring now. Like we at Singh and Associates, we do our docketing on our own proprietary system, as well as the couple of clients, they have asked us to maintain their dockets as well onto a global docketing system that they have purchased and they have the licenses for. So somewhere I think that the comprehensive IP policy should definitely include identification of IP, training the people at R&D, marketing and legal at least on what IP points that they should keep in mind. And this is an ongoing process, Neeraj. So if an attorney is a retainer for, if a IP attorney particularly is a retainer, I think one of the responsibilities of the retainership agreement should be a quarterly basis evaluation as well as training of different departments. So you can shuffle the departments in between. What we do is at times R&D is kept with the legal, at times the sales team or the marketing team is kept with the legal, so that we can emphasize even the minute details of packaging. It goes a long way once your IP is registered, and how well are you able to notify the public at large that this product involves a patent, this product has a registered trademark, this product can be a subject matter of design registration. So these aspects do come up, and there are minor changes over a period of time. So yes, continued training, identification of IP, registration, as people are now aware how important it is to be aggressive about registration. Here I would say for emerging technologies, especially because the technology is still in a domain where standardizations are yet to happen, and everybody is trying to find the better ways of doing things, better ways to solve a problem that is there in the market. So I would say that be aggressive on filing of IP, be aggressive on getting the protections for every other innovative process, every other innovative product that you think that should be marketable in coming times. And once that you get the patent for is definitely very valuable, and is an IP by itself, sellable product. And the ones that are applied for still looks good on your portfolio. So if you're approaching an investor, if you're approaching a client, if you're approaching a buyer, they would be definitely impressed by a portfolio where a lot of patents are getting applied for, are under research, and are granted for that matter, for sure. So these are the stuff. I would again come back to do not treat the timelines as something that is secondary. So that should be definitely always in mind of the in-house counsels and all the IP aware companies. Then monitoring of IP, I would kind of extend it by saying that there is a service called watch services in IP. We as a law firm also provide multiple of our clients. And India being such a huge market, I think everybody should be very much aware about keeping a track on what your competitors are doing, keeping a track on what they are applying for as a protection, and then gearing up your own level of R&D and looking at the technologies that we want to focus. So monitoring, watch services, and lastly, the management of IP, timekeeping, docketing, global management of IP. These are the stuff that we as a law firm have implemented very successfully for multinational clients as well. So this is something that firms also should look into. Yeah.
Okay, wonderful. So not only the policy, creating a policy is important, but the way you implement it and audit, periodic audit is a very important suggestion. Now, though IP provides protection to proprietary information, it is also crucial to understand what strategies should companies have in place where they say cannot register their IP due to any reason. Say the application was not drafted properly, hence the claims were not drafted properly, patent application rejected, or conflicting, I would say, marks in trademark registration, or or they decide to keep the information a trade secret. So in these situations, what would you recommend?
See, first of all, I'm not a very big fan of keeping trade secrets because any litigating lawyer will tell you how difficult it is to kind of prove that this data was marked as confidential. And the courts would also look into the level of confidentiality that you maintained within the organization. The level of confidentiality was there with respect to divulging the information, even internally, So that is something that is put to a strict test, once you want to litigate on that. So confidential information, trade secrets, yes, there are certain IPs, like if it is a recipe or if it is something to do with fragrances, you do not have very strong IP protections when you get them registered and stuff. So yeah, there is subjectivity involved over there, and companies do prefer keeping the trade secret to that level. But as the times are changing, I would say companies should make a very informed decision with respect to trade secret and following trade secrets as something that they want to have a protection on an ongoing basis. So I would say if it is imperative, like they do not have an option of going for any registered type of IP, then perhaps they can choose this kind of protection and have a very strict policy around it. Mind you, it is one of the toughest job for a litigating lawyer and IP lawyers to prove that how confidential was the information when it comes to the terms of contesting with the opposite party. So identify the IP. Why not go ahead and register it? Registration would give you a very solid case against any infringer. So have that work done. So like you mentioned, like if in case the application for trademark or an application for patent was not made properly, or in case there was some luckiness, I don't think one should take that as a reason and then go for a trade secret protection or maybe opt for that kind of an approach. That would be foolish, I would say. In today's time, have your IP registered, have it at the government side, and then enforce it as strictly, as fiercely as possible. So, but yes, if there is no other option with you, go ahead with trade secrets and keep it as documented as possible. So that tomorrow, if you want to raise a case, you should have some implementation, some proofs that how valuable or how confidential the information was treated within the organization.
Okay, wonderful. Now, the aspect related to the development of these technologies. So on one hand, they are being developed domestically in India as well, but a lot of them are also being licensed from outside India. So if there is an instance of infringement, can a foreign licensor independently institute proceedings against third-party infringer in India, or can the Indian licensee institute that proceeding independently, or a third situation where they would need to collaborate to institute any such infringement proceedings in India? What would be the best strategy in your view?
Yeah, this is like one of the very prominent questions that I think any in-house counsel should put forward, especially in the emerging technologies zone, because as they say that if the light bulb is already there, you need not reinvent it. And if that is something that you want to use, take a license and use it, right? So that is definitely something that should be kept in mind all the time. Then when you are working in a technology field, innovation field, please don't rush every time to create something new. There are opportunities, there are ways to have the patented product, or to have the such an innovative product implemented in your own domain, in your own jurisdiction, maybe by way of getting the license, And one thing that I would like to highlight over here with respect to Indian audience is patent that is registered in or granted in US is not enforceable in India, because I get a lot of questions like that okay, they have a patent in US and then we want to have you use that patent. So how do we go about it? Do we write an email to the owner and seek how to proceed about licensing that particular getting a license over that particular technology or not? And to my surprise, people are not aware that you need to have a patent in India. So it's a jurisdictional right. Every kind of IP is a jurisdictional right. So it is very, very important to look whether that particular technology is patented in India or applied for patent in India. Do exhaustive research. Do hire best of the IP attorneys, best of the research analysts, and find out if there is that technology, a family application, what we call filed in India or having a patent. Then only you need to get that license, number one. Otherwise, if they have chosen not to file in India, it is free for you. It is free for that technology based company to use that particular innovation to their advantage. So one thing that I wanted to highlight is, please do your homework properly before approaching anyone for a license. And yes, that's a very good suggestion, that please do not run always and be jumping on every opportunity of innovate. There are many good solutions out there, which I think the patent owners would gladly like to license out and give to the local players at a very reasonable cost. So find out a way to get a license over a registered patent or even a pending application. So I would just demarcate that. In case of a pending application, you can get a license. It's a IP. It's a proprietary property of that particular owner, innovator. But yes, you do not have a provision to record that license into the Indian Patent Office or Trademark Registry. That would only happen once the application gets registered or a patent gets granted, and then you have provisions to record the licensee as a registered licensee for a certain patent or a certain trademark. Coming to the question of how they should proceed in case they get a license, they are now into a license agreement with the owner, and then they are validly using that particular IP in India to the exclusion of others. So one needs to be very careful when they are entering into a license to make it an exclusive license as far as the jurisdiction is concerned, and then to have provisions like, in case there is an infringement and once the IP is granted, they can have the condition of the IP owner joining in as a co-party to the suit. Being a registered licensee, you do have the right to sue for infringement, but you need to have the owner as a co-party. So that can be put in as a provision into the license agreement, and definitely it will be a very good case. And yes, if the question, the licensee over here can definitely institute a suit and protect the IP not to be kind of copied by others. So yeah, that is very much possible.
Okay, great. So now we are almost towards the end of our time. So one last question to you. From this discussion, I understand you are an ardent advocate of registration of IP, and you want to cautious every client, everybody in the industry, that they should be protective about their IP, and registration is the first step. What if I decide not to register IP at all, and yet I would want to have a licensing structure of business? Is that allowed? And what risks I would be getting into?
See, when you say that you don't want to register the IP, the very premise is, if you want to stop others, you must have the registration, right? You want to give out the information with the caution that, okay, I'm giving it out to you for research, for study, for enhancement, whatever. But as far as the commercial aspects are concerned, please take a permission from me, or maybe I'll be the sole person who will be manufacturing this product, right? So if you choose not to register it, you want to keep it as a trade secret, and then you want to give it out to others, that would be a very surprising decision, by the way, but you want to give it out to others, the trade secret, to perform those, or maybe to manufacture those products, or whatever, whatever kind of IP we are talking about. Now imagine a situation, and you being an attorney would kind of appreciate this, that as it's already very difficult, when I said that you need to enforce, if you want to enforce a trade secret, you need to, open up the entire records in front of the court to their satisfaction, that, okay, this was actually a highly confidential and a trade secret, and that everything go under the TOTS regime. And, the agreement clauses would play a huge role on that. Now imagine you licensing it out, you're giving it out to an outsider, and you don't know, you don't have the direct supervision, how much the court would appreciate that. Then definitely you have diluted the trade secret standards. And I would be very skeptical in case you are able to exclude others other than the licensee also. It'll be even a more difficult case for any attorney who's defending that kind of action, or maybe instituting a suit. All the best for him. But I would again say, if you have a right, if you have an innovation, if you have artistic, contribution to a thing, there is a regime of law for you all. Be it art, be it a design, be it a patent, be it a trademark as a brand. There is an institution of law in itself, a branch of law in itself, dedicated for you to register it and reap the benefits out of it. So why to shy away? There should be a good reason for it. Yeah. Unless you don't have that, please go ahead and in a country, in a huge market like India, and with so much of, economically also, I can tell you, because we have multiple international clients, India, the IP registrations are really very, very economical and cost effective. And the protections and the enforcements are really, better than any of the developing nations. So, and the huge market everybody knows about. So I don't see an emerging market player, emerging technology market player shying away from getting the IPs registered and enforced. Yeah. So that is the advice that as an attorney, I would want to give. And yeah, coming to the startup side, I would just like to touch upon this. When I emphasize so much on monitoring IP, and I emphasize so much on having the softwares in place, having the timelines, I know that these all are cost-intensive things. So what you can also do as a suggestion is, the external counsels, normally a good IPR firms, do have these softwares in place, do have these docketing systems in place. If you keep them as retainers, it's a very good and very rounded kind of decision, I would say, where you get all these points covered, and not at the cost of the high license fee of these docketing softwares. So that is something that perhaps the proprietor of these innovative technology-based companies can consider. Research about the attorneys that you're hiring as a retainers, and give it to them. They would be more than happy to maintain the docketing systems for you.
Okay, great. So you continue in your position. That's wonderful.
Yeah.
And so good key takeaways from this discussion, which I understand, is first, you should have means to understand what IP is and what IPs do you have. Register that in the jurisdictions you want to do business. Create a robust IP policy and mechanism to safeguard it, not only from internal sources, but external sources as well. And I would add, have confidentiality agreement with whomsoever you discuss your proprietary information or share it with for any business or R&D purposes. And in matters of cross-border, again, you need to verify, you need to understand how well you can protect. So consult a good IP counsel so that he or she can guide you to the best of their ability to safeguard your IP. And then, of course, monetize it. It's your IP. Thank you so much, Shrimant. Thank you for this wonderful discussion and insight.
Thank you. Thank you, Neeraj. Always a pleasure speaking to you.
Thank you, gentlemen, for sharing your knowledge on emerging technologies and IP concerns. Ladies and gentlemen, if you are facing any issue related to this event, please feel free to visit the Help Center. Our representatives are there to assist you.